Hi, I'm Ellen Cookman, estate planning attorney and founder of Cookman Law. If you're navigating public benefits like Medi-Cal, SSI, SSDI, or if you're thinking about setting up a special needs trust, this masterclass is for you. We've brought together our most helpful videos in one place to walk you through everything you need to know, from eligibility rules and payback provisions to how to actually use a special needs trust and how to avoid common pitfalls. These are the exact questions we hear every day from clients, and chances are you've had them too, like, what are the income limits for a Medi-Cal in California? Can Medi-Cal claw back from a CalABLE account? Do I still need a special needs trust with all the new laws? We'll answer all of those and much more as we go. So whether you're a parent, a caregiver, or a trustee, grab a notepad, settle in, and let's dive into this comprehensive guide to protecting your loved one's benefits and planning for their future. So you may be receiving Medi-Cal, and let's say that your income goes over a certain amount, and now all of a sudden you have to start paying share of cost. This can be punishing, but new laws are coming in January 2025, which should greatly reduce your share of cost. And you'll be celebrating with me. I'm going to explain these changes in this video. I do need to note that the California legislature has not yet funded this wonderful improvement, so we're still keeping an eye out for it, but it may not be available in January 2025. So a share of cost is a monthly premium that someone receiving Medi-Cal benefits needs to pay if their income goes over a certain amount that month. So that Medi-Cal income limit is 138% of the federal poverty level. In 2024, this is $1,732 per month for an individual and $2,532 per month for a couple. If your income goes above this amount, which is not very much, you have to pay what's called a share of cost. And I explain how we've been calculating this share of cost in my video, Medi-Cal Updates for 2024, What You Need to Know, starting at about 2 minutes in. So basically, they allow you to keep $600 of your monthly income. This is known as the monthly maintenance income limit. Then any other income over that amount needs to go to Medi-Cal for your share of cost. Can you imagine? They think that living on $600 a month is enough? This amount, by the way, hasn't changed in 40 years. Because of this, a lot of people were trying to buy additional health insurance policies to decrease their premium, or they had to purchase health insurance policies over Covered California using subsidies, or they just paid the share of cost and suffered. But here's the really good news. Starting January 1st, 2025, the law is changing so that the monthly maintenance income limit isn't set at $600 a month anymore, but instead it's going to be increased to 138% of the federal poverty level, which is the same amount as the income limit. And it's going to be indexed for inflation. I mean, doesn't this make sense? So this means you'll only have to pay share of cost of the amount over $1,732 a month of income. So you get to keep that income, up to that amount, and then anything over paid to share of cost. I think this is a terrific, terrific development.
Hey everyone, if you like my mom's video, like and subscribe.
I want to share an example with you so you can see just how much of a game changer this really is. Let's say that somebody's receiving $2,000 a month in income. Before January 1st, 2025, they get a $20 deduction, just a freebie. And then let's also say that they're paying Medicare Part B, and so they get to take a deduction for that, which would be, in this case, $174.70. So their net income, rounded, would be $1,805. Uh-oh, that's just a little bit over the $1,732 a month. So they're penalized a huge amount. They get to keep the $600 monthly maintenance income limit, and then everything else they have to pay to Medi-Cal as their share of cost, which in this example is $1,205 a month. I mean, this person is they're hardly making anything. They're making $2,000, and 60% of that is going to Medi-Cal for their share of cost? Ridiculous. Okay, so this is how it changes January 1st, 2025. That same person, they're making $2,000 a month. And by the way, They haven't changed anything, it's just the rules are changing. So they still get the $20 of the income deduction, and then they're still paying Medicare Part B, $174.70. So their net income is the same, $1,805. All right, nothing's changed so far. But what changed is the monthly maintenance income limit, and that is now $1,732 a month. At least it's going to be a little bit more because it'll be in 2025. We don't know the numbers yet at the time of this filming. So the share of cost, what is it now? Only $73 a month. So look at that. The share of cost has decreased from $1,205 a month to $73 a month. A savings of over $1,100. I'm telling you, this is going to help so many folks to make ends meet. So I ask you to please pass this information along to anyone who might benefit from it. This might be somebody who's receiving Medi-Cal insurance and they're currently paying a share of cost. They need to know that their share of cost will likely drastically reduce. So now they can use their money for their living expenses and other necessities instead of shipping away 60% of their income. Now, please note that our office does not assist with public benefits applications. We specialize in estate planning, special needs planning, and trust administration, but we wanted you to find out this information, so I hope this has been helpful to you. A viewer asked about monthly income limits for qualifying for California Medi-Cal. We will cover income limits in our share of cost section, which is in Chapter 6 of this masterclass. If you or a loved one receives Medi-Cal, you've probably heard about the state trying to take back some money after someone dies. It's true. California can seek reimbursement for certain benefits through a process called estate recovery. But not everything is subject to payback. In this video, I'll break down exactly when and how Medi-Cal can recover money, what kind of assets are at risk, and what steps you can take now to protect your family. So Medicaid, which is the federal program, has what's called an estate recovery program. And this requires states to seek reimbursements for certain benefits. In California, there are really 2 times our state is allowed to seek a reimbursement claim. That is, Medi-Cal can get their money back after a Medi-Cal recipient dies. But Medi-Cal isn't allowed to go after any and all money that the Medi-Cal recipient might have when they die. In fact, they can only pursue claims in these 2 situations, and they're both described in 42 U.S. Code Section 1496P. That's the code that talks about Medicaid recoveries, if you care about that sort of thing. So the first situation where Medicaid can bring an estate recovery is when a deceased Medicaid recipient has an ownership interest in an asset. So this is spelled out in subsection 2. It says, the state shall seek adjustment or recovery of any medical assistance correctly paid on behalf of an individual under the state plan in the case of the following individuals. A, they seek recovery from the individual's estate, and B, they have to be 55 years or older when they received that medical assistance. So that sounds pretty serious, right? I mean, recovery from your estate for all medical assistance? Well, California has limited that. In 2017, California passed a law called SB 833. This law limited the types of assets that Medi-Cal can bring a recovery claim on. Now those assets need to be part of a deceased person's estate, like it says in the code, but what really constitutes that estate? Well, California says if an asset is subject to probate, that's when you know it's in an estate and Medi-Cal can bring a recovery claim. So if there's any way of getting an asset to the next generation or somebody else without going through probate, it's not subject to recovery. So for example, if an asset is held in a revocable trust, it's not going to go through probate when the settlor dies, and thus it's not subject to a Medi-Cal recovery. Or if an asset is titled in joint tenancy and it automatically goes to the other joint owner when the first person dies, no Medi-Cal recovery. Or if it's like a retirement account and it has a designated beneficiary named and it goes straight to that beneficiary, no recovery. Also, if the total assets in the estate are less than about $200,000, then you can use a small estate affidavit to get that money directly to somebody else no probate, no recovery claim. So really, it's only the assets going through probate that Medi-Cal can bring a claim against, which is pretty awesome. So how big will this Medi-Cal claim be? Well, Medi-Cal starts counting all the assistance that somebody's gotten starting at age 55. This can be in a nursing home, or it can be if somebody's living in the community. So here's an example. Let's say that Medi-Cal has paid $300,000 of health assistance for somebody before they turn 55, and then $200,000 after they're 55, and then that person dies. How big will that recovery claim be? It would only be $200,000. It's only the money starting at age 55 that the person received in medical assistance. Now, the other type of Medicaid recovery that's possible is against a first-party special needs trust when the disabled beneficiary dies. This is also called a self-settled trust. This is a special needs trust that holds the beneficiary's own money. Now, this is spelled out in our favorite section, 42 U.S.C. 1396 P, but then it's D4A. So take a look. And that's, by the way, that's why first-party special needs trusts are also sometimes called D4A trusts. So it talks a lot about different things in D, and then it's saying that this subsection, which prevents recovery, shall not apply to a trust containing assets of an individual under age 65, right? So this is where we get the rule that a first-party special needs trust can only be funded with the beneficiary's money up till age 65, who is disabled, and which is established for the benefit of such individual by certain people, if the state will receive all amounts remaining in the trust upon the death of such individual up to an amount equal to the total medical assistance paid on behalf of the individual under a state plan. So basically, everything that Medi-Cal has paid for on the beneficiary's death, Medi-Cal gets to bring a recovery.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
Note that there's no limitation for age 55 and up. So that means anything that Medi-Cal's paid for the beneficiary starting at birth, going up to when the beneficiary dies. And there's no limitation for you can only recover against things, once the first party special needs trust was set up. All right, so they can bring a recovery, they calculate the recovery claim on everything that Medi-Cal has paid for over the beneficiary's lifetime. Now, please note that this doesn't apply to third-party special needs trusts, which are the more common ones out there. That's when somebody else sets up a special needs trust for the benefit of a disabled person. And that's someone else, like a parent, a grandparent, a friend, a family member, an auntie, then funds that trust. So the beneficiary does not put their money into the third-party special needs trust. There's no Medi-Cal recovery for third-party special needs trusts at all. So let's look at that last example. There is a disabled person who received $300,000 worth of medical assistance by Medi-Cal up until age 55, and then $200,000 more after age 55 until they died. From a first-party special needs trust, how much could Medi-Cal bring a claim against? $500,000. The entire lifetime of that beneficiary. I know it's different than the recovery against the amount that might pass in probate. Yeah, this doesn't seem fair, but it's the law. Now, you may have heard of IHSS in California, In-Home Support Services. IHSS is home-based, and it helps pay for caregivers who are providing help for activities of daily living to people who have developmental disabilities, or they might need some elder care. IHSS is delivered under the Medi-Cal umbrella, so Medi-Cal can bring a recovery claim against any money or services paid for by IHSS. But what about other public benefits programs? Can they bring a reimbursement claim? None of them. So this means that there's no recovery claim against a beneficiary's money or a first-party special needs trust if that beneficiary was receiving SSI, SSDI, CalFresh, otherwise known as SNAP or food stamps, Medicare, or Section 8 housing. I mean, you might expect SSI to bring a reimbursement claim since they're so strict while you're alive, and stingy too, but they don't have an estate recovery program. However, if SSA, Social Security Administration, determines that they've overpaid what the beneficiary received under SSI or SSDI, they can claim a recovery for that overpayment. So it's kind of like, oh, they paid too much, they get that overage back. but it's different than a Medi-Cal recovery claim. Okay, so how might this affect you? Well, if you're receiving Medi-Cal, you'll definitely want to set up your assets to avoid a Medi-Cal recovery claim on your death. This means you should set up a revocable living trust to hold all of the assets that you might have in your own name. Now, why would you have assets in your own name? Well, there's some assets under Medi-Cal that are exempt, right? That could be your house, a car, burial plot, a retirement account that's not paying out. There's different things that you can still hold. But on your death, if your house is titled just in your name, then guess what? That house would go through probate and it's subject to a Medi-Cal recovery claim. I don't think anybody wants that, right? And you're having to deal with the probate court and all the probate fees and everything. It's like a double whammy. Not ideal. So in that case, you should put your house into a revocable living trust. Then when you die, your house doesn't go through probate and there's no Medi-Cal recovery claim. Also, if you want to leave money to somebody who's currently receiving Medi-Cal, you should leave it to their third-party special needs trust instead, since those types of trusts are not subject to Medi-Cal recovery claims. Don't leave the inheritance directly to the disabled individual, since they'll need to turn around and put that money into a first-party special needs trust in order to keep their Medi-Cal benefits. And then when they die, all of that money in the first-party special needs trust is exposed to a Medi-Cal recovery claim, and that could completely deplete the trust. So, estate recovery can really catch families off guard, especially when somebody's home or trust is involved. If you or a loved one is receiving Medi-Cal, it's so important to plan ahead. Setting up a revocable living trust, understanding the difference between first-party and third-party special needs trusts, and properly titling your assets can make all the difference. A viewer asked if CalABLE accounts have to be probated upon the owner's death, and if CalABLE accounts are subject to Medi-Cal clawback. I want to expand on this. The CalABLE account should avoid probate as long as it stays under the freebie amount of $208,850 as of 2026. And Medi-Cal doesn't have a clawback from ABLE accounts. But be careful, it does claw back from ABLE accounts in other states. So for a long time, in order to qualify for SSI and Medi-Cal in California, you had to be poor, and all of your money had to be held in a special needs trust. But times have changed. To qualify for Medi-Cal now, they don't look at your assets anymore. So do you still need a special needs trust if you're receiving Medi-Cal? Or can you use a less restrictive trust? We'll talk about that in this video. So if you're disabled for many years, in order to qualify for Medi-Cal, which is called Medicaid in most states, you've had to have under $2,000 of countable assets. And that's very, very low. And then if you receive some money from somewhere like a litigation settlement, or maybe an inheritance from somebody that goes directly to you, you need to set up for yourself a first-party special needs trust and transfer those assets into the trust in order to protect your Medi-Cal benefits. And I discussed this more on my video, How to Receive an Inheritance While Receiving Public Benefits. Well, that just changed in California. Starting January 1st, 2024, Medi-Cal isn't considering assets anymore for eligibility. Wowzers, this is amazing. I talk about this more on my video, Medi-Cal Updates for 2024, What You Need to Know. So I've had a lot of clients since then come and ask me, do they still need a first-party special needs trust to protect their Medi-Cal benefits? And I want to break down the situations where I think you still do need a special needs trust, and then also where you can use a different type of trust. So where you still need a special needs trust, first of all, if you're still receiving SSI benefits, supplemental security income, then you do need a special needs trust because SSI has an asset limit of $2,000 and that hasn't changed. That's federally based. California has not changed it. So every state, in order to receive SSI, you need to keep your assets below $2,000. And also, Section 8 housing just passed an asset limit of $100,000 as of January 1st, 2024. So in order to qualify for Section 8 housing, you need to have your assets below $100,000. Also, you might want a special needs trust to protect yourself from financial predators. A special needs trust always needs to be managed by somebody else. Someone else has to be the trustee. So if you're worried that you might be taken advantage of, you might want to transfer your assets into a special needs trust, and then somebody else is looking out for your benefit. But there are some people who may not need a special needs trust anymore. That could be people who are just receiving Medi-Cal, or maybe they're also receiving SSDI benefits or Medicare benefits, because SSDI and Medicare have never had an asset limit requirement. So you might think, okay, well, that's great. That's the asset limit, but what about the income limit? Well, Medi-Cal does still have an income limit. That hasn't changed. If you're disabled and you have more than, right now, it's $1,732 of income, that can bump you into the Medi-Cal share of cost category, where you have to pay a really high deductible for Medi-Cal services. I've discussed this recently in my video, how to reduce your share of cost. So if you're receiving Medi-Cal and you have a revocable trust, and the trustee, whether it's you or somebody else, distributes cash to you, that counts as income. And that could count towards that $1,732 a month income limit. And if it bumps you over that limit, now you're paying share of cost, which is horrible. And we don't want that. So what's the solution for someone who's just receiving Medi-Cal or, other benefits that don't have an asset limit, but they still have to look out for their income? So there's this type of trust called an OBRA 93 trust. So OBRA stands for Omnibus Budget Reconciliation Act of 1993. So this was actually passed a long time ago, but we never really looked into it because that asset limit of $2,000 was so onerous that what I'm about to describe just wouldn't apply, but now it does.
Hey everyone, if you like my mom's video, like and subscribe.
So an OBRA 93 trust is really any trust that you set up for yourself, except it's not a first-party special needs trust and it's not a pooled special needs trust. It can be revocable or irrevocable. You could manage the trust or someone else can manage the trust. It's really like a revocable living trust, but there are some constraints. So from this OBRA trust, if you make a distribution, or whoever the trustee is makes a distribution to a third-party vendor, like pays directly for your rent or buys stuff for you, anything that doesn't go to you as cash, that does not count as income for public benefits purposes. But if the trustee makes a distribution to you of cash from the OBRA 93 trust, then that does count as income for Medi-Cal purposes, and that could add up and maybe bump you over that share of cost limit. Also, an OBRA trust can't mandate income distributions. So for example, it can't say the trustee shall distribute all of the income every year directly to the beneficiary. Or maybe it doesn't say, the trustee can distribute 5% of the principal, or the trust says the trustee shall distribute 5% of the principal directly to the beneficiary every year. Those types of things are not allowed in an OBRA 93 trust. So can the beneficiary be trustee of an OBRA 93 trust? Well, I already mentioned, yes, they can, but I usually recommend that they not act as trustee. And why would that be? Well, it can be kind of complicated to understand what can you distribute and what you can't. And a beneficiary might just think, I'm just going to take out this cash just this one time because it's just easier than paying directly for a thing. I just want some cash. And then that could interfere with their Medi-Cal benefits and bump them over that share of cost. So the beneficiary might not understand these nuances, or maybe they just forget. But either way, I think that's really dangerous, and we don't want to even approach that. Now, please keep in mind that this is all really new. Okay, and we're all still learning about it. Also, the Department of Healthcare Services, which runs Medi-Cal, they're just starting to learn about this too. And so they may have some pushback. If you start talking to them directly about OBRA 93 Trust, they may not know what you're talking about because they still have a lot to learn as well. Okay, so finally, if you're not getting Medi-Cal at all, but you're getting SSDI or child disability benefits and or Medicare, then really you shouldn't need a special needs trust. In case you decide, somebody decides that they want to set up a special needs trust for you, but it really isn't necessary because those passive income limits and the asset limits really don't apply for those types of benefits. Okay, so here's the breakdown. So a special needs trust might not be needed if you're getting SSDI and Medicare and you're not receiving SSI, Medi-Cal, or Section 8 housing benefits. In that case, you might just use a regular revocable trust. Now, if you're receiving Medi-Cal benefits but not SSI or Section 8 housing, then you can use an OBRA 93 trust. And if you are receiving SSI and Section 8 housing benefits, then you still do need a special needs trust because they're looking at your assets, and anything held in a revocable trust counts as a countable asset for public benefits purposes. All right. So I know this might feel like it's as clear as mud. So what do? I encourage you, if you have questions on this, to call our office if you're in California. You can reach out, we can talk you through, okay, which type of trust might be the most appropriate for you and your loved one. So navigating a trust administration after a loved one's death is hard enough. But what happens when there's a beneficiary who has special needs? Did you know that you can create a special needs trust during this process to safeguard that loved one's future without interfering with their public benefits? In today's video, we'll walk you through how to set up a special needs trust during the trust administration process. We'll cover the crucial steps to get it up and running smoothly, and also make sure that it's funded properly, ensuring that your loved one is fully supported while meeting all the legal requirements. Now, before I get started, I wanted to mention that I have a monthly free newsletter where I discuss all things special needs planning, and I invite you to click below to be added to that newsletter. Okay, so let's say that you're trustee of your mom's trust and your mom recently passed away, and you've gone through the trust administration process just like I described in my video, what happens to my trust when I die? Now you're ready to distribute the money to all the beneficiaries. And let's say you have a disabled sister, and that trust says that the money is supposed to be distributed to the special needs trust for your disabled sister, and it provides the terms of that special needs trust. So I want to provide an overview of all the steps you'll need to get the money from your parents' trust to your sister's special needs trust. So first, you need to get a tax ID number for that special needs trust. It's also called an EIN. So why do you need one? Well, you can't use your mom's social security number for this because she's already died. And you don't want to use the disabled beneficiary's social security number because the money in the special needs trust isn't considered their money. So what do you do to get this tax ID number? Well, first you go online to the IRS website, and this is what you'll see. So you find employer ID numbers under business and self-employed. Now, I want to mention this should be free. There's a lot of websites out there that charge you for this. That's the wrong website. You want to go to the actual IRS website to get this. And please note it's only open on the weekdays. So when you set it up, they'll ask what type of trust is this? You know, typically for a special needs trust, you enter that it's an irrevocable trust, but you'll want to double check with your attorney on all of the different things. You also want to enter who's the responsible party, and that's usually the owner or the controller of the assets. Then you'll provide the trustee information, which is probably you, and your contact information, whether the trust has employees, my guess is it doesn't, and in what month and year will the trust be funded. Then once you enter everything, they'll ask you, do you want to get this EIN online or do you want it to be mailed to you? Well, if it gets mailed to you, it takes like 2 weeks, versus if it's online, you get it immediately. So I would say online. Here's an example of what you'll receive. So you can see on here, the employer ID number is up at the top. It's the second line from the top. And it'll write out the name of the trust on the left and also the name of the trustee. And I've blacked that out for privacy purposes. Sometimes it initials things, like you see it says special needs TR, right? And then that stands for trust. And then TEE stands for trustee. Don't be alarmed if they shorten things. Now I want to mention, if you get the tax ID number wrong, it's really a pain to go back and fix it. If you enter any information wrong, it takes the IRS sometimes months to fix it. So please don't just rush off and quickly get the tax ID number. Like, really be methodical about it and make sure you have all the information right before you enter it into the system.
Hello, did you know that my mom helps people all the way through the state of California from top to bottom? Go give her a call.
So the next thing you typically prepare is something called a certification of trust, or COT. This is basically a shortened version of a trust document, which provides banks and other entities the information that they need to set up an account in the name of the trust. Probate Code Section 18100.5 states what should be on a certification of trust. So it should state the existence of the trust and the date of execution, that's when it's signed. It should identify the settlers and the trustees of the trust. It should list the powers of the trustee, or maybe attach the powers to the back. It should state whether the trust is revocable or irrevocable. It should state which trustees need to sign in order to exercise powers of the trustee. It should list that tax ID number that you just obtained and a statement that the trust hasn't been revoked or changed so that the bank can rely on the certification of trust. Finally, it should say how the title to the trust assets should be held. Now, this is created so that a bank or other entity can rely on the certification of trust and not have to look through the entire trust document. And also, it provides you privacy, so you don't have to provide the entire trust document. Now, note that some banks still insist on seeing a copy of the whole trust. I don't know why. Banks can be difficult. Now, I'd like to share an example of a certification of trust with you so you can see what this looks like. It goes through those very items that I mentioned. So special needs trust, right? There's the settlers are these people, and now the trust is irrevocable, can't be changed. The trustees are these people, and then you fill in the ID number, and then you say how the trust assets should be titled, right? What should it say on that bank account? It can attach excerpts from the trust, and then it says third parties can rely on the terms of the certification of trust. That's what reassures banks that they won't be liable for relying on this. I think banks only care about liability, but maybe I'm paranoid. And then it says that the trust hasn't been amended or revoked. Finally, it says that banks should rely on this. They're required to by law, and then you sign it. Okay, so then your next step is to bring that IRS letter showing the tax ID number plus a copy of the certification of trust to the bank where you want to set up an account in the name of the special needs trust. And then the bank can assist you in setting up the account. Then once that account is set up, you can directly transfer the inheritance of your disabled sister from the parent's trust account to the account that you've set up for the disabled sister. You don't want to transfer the money directly to the disabled sister and then she turns around and puts money into that trust, because we're setting up a third-party special needs trust here and money can't come directly from her. So that's a big no-no. So make sure that it goes from the revocable trust straight to the special needs trust. So now the special needs trust is funded. Yay! But we have one last step. If your disabled sister, the beneficiary, is receiving supplemental security income benefits, you need to report a copy of that trust to the Social Security Administration. I typically send a cover letter explaining all about the special needs trust and why it shouldn't be considered a countable asset for SSI purposes. I want to show you a copy of a sample letter. So in this example, we have the disabled beneficiary, Rupa Singh, and we're writing this to the Social Security Administration. You send it to the county where the beneficiary is living. So in this case, the beneficiary is in San Mateo County. So it says, to whom it may concern, please note that a special needs trust has been set up for Rupa. And we've put Rupa's social security number on there so that the Social Security Administration can find her file. And it says that it's a third-party special needs trust that's being funded with money that Rupa has never owned and she won't own. And then we walk them through the POMs, which is basically what Social Security Administration follows to make sure that it's a valid trust. So we're pointing them to their own handbook. I provide several POM sites and I say, why does this apply? And then I explain that the money came from the parent's family trust and it went straight to the special needs trust, so it's not Rupa's own money. And then we reiterate that it's not an available resource. So we say, hey, it's a third-party special needs trust. And I typically send this to the Social Security Administration under certified mail to confirm that they received it. So if they ever come back and say, hey, we didn't get a copy, you can show them that little green slip that says, oh, yes, you did. One viewer commented and asked, can I set up a trust holding an investment account? Yes, you can. Here in the United States, we're all used to seeing deductibles from private health insurance companies. Medi-Cal has something similar, and it's called share of cost. This is the amount that the participant needs to pay before Medi-Cal will kick in. Basically, it's a required out-of-pocket expense. The main problem is that a Medi-Cal share of cost can wipe out most of your money. This isn't a position we want anyone to be in. In this video, I'm going to share some things that you can do to avoid triggering a share of cost or to reduce your share of cost. Let's dig in. Many disabled individuals all over the United States rely on Medicaid, which in California is called Medi-Cal, for their health insurance. There's quite a few ways you can become eligible for Medi-Cal if you're disabled, but I really want to focus on two ways. The first way is called federal poverty level Medi-Cal, which doesn't have a share of cost. And then the other way is called medically needy Medi-Cal, which does have a share of cost. So here's how it works. Your income, that is your modified adjusted gross income, or MAGI, can be up to a certain amount. That amount this year in 2024 is $1,732 a month. So that's kind of the magic number. If your income is lower than that amount, you can qualify for federal poverty level Medi-Cal. But if your income is above that amount, then you're bumped into the medically needy Medi-Cal category, and you do have to pay a share of cost. So why does this matter? Well, essentially, a share of cost is a really high deductible. The government basically allows you to keep only $600 for what they call your maintenance needs. And then you have to spend the rest of the income that you've received that month on Medi-Cal expenses. Only $600 a month to live on? Talk about ridiculous. But I have to share, there's some really good news on the horizon for that horribly low medical needs allowance of only $600. So starting January 1st, 2025, the maintenance need allowance is going to change to 138% of the federal poverty level. And this amount will increase annually. So guess what? That amount right now is $1,732, which is the same as the cap for a share of cost. So very soon, you'll be able to keep the first $1,732 each month of income, and then you only have to pay what's above that towards your Medi-Cal share of cost. That's much more reasonable to me. But what if you don't want to pay any share of cost at all? So let me give you an example. So let's say you receive $2,000 a month in SSDI or child disability benefits. That's over the $1,732 a month of the cap. So now you're bumped into medically needy share of cost. So how much will you pay for share of cost in this example? So for the rest of 2024, you take the gross income of $2,000 and then you subtract the $600 maintenance need and you have a share of cost here of $1,400. That means you're paying over 2/3 of your income towards Medi-Cal expenses. Can you believe it? But starting in 2025, under these numbers, you'll only have to pay $268 a month towards your Medi-Cal share of cost. So that's much better, but it's still not ideal. And this comes up a lot when you have somebody who's been receiving SSI benefits for years. Let's say they're getting, right now in California, you can get up to $1,183 a month of SSI. It's lower in most states, but in California, we bump it up a bit. And so let's say you've been receiving that for years, and that's under the $1,732 cap. And so you're receiving the federal poverty level Medi-Cal, but then your parent retires, and your parent, let's say they get $4,000 a month from Social Security, and you're entitled to child disability benefits of $2,000 a month. And this is under the parent's work record. So I talk about this more in my video, Public Benefits Timeline, and I encourage you to watch that.
Hey everyone, if you like my mom's video, like and subscribe.
So in this case, now all of a sudden, this person's income is bumped over $1,732 a month, and now that's triggering a share of cost. So that's awful. Now, keep in mind, after receiving child disability benefits for about 2 years and 5 months, you start receiving Medicare benefits. So at that point, staying on Medi-Cal may not be as important to you. But there's a lot of things that Medi-Cal and Medicare might cover in different ways. And so it's really helpful to receive both. You can be Medi-Medi, right? You can receive Medi-Cal and Medicare. For example, Medi-Cal is really important if you're receiving in-home support services. And it also does a really good job paying for prescription drugs. And Medi-Cal is the only one that'll pay for a stay at a skilled nursing facility. But even if you plan on just relying on Medicare for your health insurance needs, you still have to wait another over 2 years in order to qualify for Medicare. And you're paying a share of cost during that time. It just doesn't make sense. So let's look at some deductions that could bring you under that cap in this situation. So you can reduce your MAGI, your gross income, so that your net income is below $1,732 a month and you don't have to pay a share of cost. So that sounds good. Ellen, how do you do this? Well, one deduction you can take is for health insurance premiums. So let's say that this person who has, $2,000 a month of child disability benefits, that they pay for Medicare Part B, a premium of, let's say, $168 a month. And they also give you a $20 deduction just because. And then let's also say that they get vision and dental insurance for $100 a month. So that's $288 in deductions. So now your net income is $1,712, which is below the $1,732 limit. So you don't have to pay any share of cost at all, as opposed to the $1,400 share of cost that you'd be paying if you didn't take those deductions. Another type of deduction you can take are just plain healthcare costs. If you have medical bills from a prior month that you haven't paid yet and they're not covered by Medi-Cal, you can submit the unpaid bill to Medi-Cal and take the amount of the bill as a deduction. So what if you just can't bring your income level to below $1,732 a month? Are you out of luck? Well, there's another option if you're able to work even just a little bit, and that's called the 250% Working Disabled Program. In this program, you have to work a little bit. There's no minimum hours working requirement or minimum amount that you have to earn. So you could be caring for somebody's pets or tutoring someone, but you have to provide proof that you're working to your county. And this could just be a note from the person that you're working for. It doesn't necessarily have to be a pay stub. If you're part of this program, here's the really good thing. They don't count your disability income, including SSI, SSDI, and CDB benefits. So if you're in the Working Disabled program, for that prior example where somebody's receiving $2,000 of child disability benefits, none of that $2,000 would count towards your net income, and you don't have to pay share of cost. Now, do keep in mind that if you're receiving in-home support services and then you have a share of cost, you're required to pay that share of cost towards the IHSS provider, and then Medi-Cal will pay the remainder of the IHSS provider's fees. So this is a lot of information about share of cost, but hopefully this video has given you some ideas on how you can reduce or even eliminate your Medi-Cal share of cost. A viewer asked in the comments, what happens if you're on Medi-Cal and you either inherit money or get a large paycheck during 1 month only? Do they stop Medi-Cal for a month? Do you get bumped off completely? If you inherit more than $130,000, which is the current Medi-Cal asset limit in California as of 2026, you're required to report that to the Department of Healthcare Services, and they will suspend your Medi-Cal benefits. Also, if that money starts generating income, that can lead to a large share of cost. You should consult with a special needs planning attorney to see what steps you can take to maintain your Medi-Cal benefits in this situation. Well, thanks so much for joining us today. I'm very excited to have two financial advisors who are just terrific with us, Ken Prodger and Scott Gill. They have an amazing practice in Santa Clara, California. So I'd love to have them introduce themselves. And just to let you know, today we're going to be talking about financial projections. How do you figure out how much to leave to a kid with special needs? So Ken and Scott, do you guys want to tell us a little bit about your practice, and then we can kind of dive into the meat of things?
Ken, go ahead. You want to get us started off as the founder?
Just kind of the older one. I'm supposed to know more. So Scott and I were we're colleagues. We have a boutique financial planning firm for special needs. In fact, the firm is called Special Needs Planning Group, and about 80% of our clients are special needs families. So it's something that we deal with literally every single day. So it's not just something we do from time to time. It's something we do every day.
One thing I will include on that as well, Ellen, is sometimes clients will ask us, are we limited to only working with clients that are here in the San Francisco Bay Area? And in fact, we have clients that are up and down the state, right? Our job is to partner with organizations and families that are in need of specialized services that we provide. And we're not limited geographically just by the zip code that we're in. So we're very flexible in terms of meeting our clients, regardless of where they may be. And that is one of the benefits that's come about from COVID and being able to work virtually.
Awesome. You guys are what we call chartered special needs consultants. Is that right?
Yes.
That's correct.
Okay. So that's like, just to let people know, that's the designation that I think counts when you're dealing with a financial advisor and you're wondering, do they really know their stuff when it comes to special needs planning? So these guys know their stuff. Okay. So I want to set the stage here for financial projections. So I just had a call with somebody who, really nice guy. He has 3 kids who are all in their, late teens to mid 20s. His oldest child, a son, has significant special needs and needs pretty much around the clock care. And his 2 younger kids are off at college, thriving and living their best lives. Okay. So one question that's coming up with him and with so many of my clients is, how much does that disabled child really need? I mean, they want to provide for the child, but they also want to provide for their neurotypical kids. How do we thread the needle? How do we balance it? And also, how do we just make sure that our clients can sleep at night, knowing that there's enough in that special needs trust to last for their disabled child's the remainder of their life, because they won't be able to work and supplement that. So take it away. Answer that question in 5 words or less. No, I'm joking.
Okay, Scott, you got the first 5 words.
Great to be here. Thanks. Very high five. Ken, do you want to get started, and I'll piggyback on?
Sure. So I think that the big thing is that what we do is that we take a look at the big question that parents have to answer is, where's their child going to live? Because that really dictates what those expenses could be. So on one side, if the child is going to live in a group home that's going to be subsidized by government benefits, their needs may be less. On the other hand, if there's some significant medical issues that maybe they want a private pay for, then those needs could be significantly more. So we don't do a cookie cutter approach, just saying, oh, gee, there's three children in the family, 2 are neurotypical, 1 is special needs. We divide the estate a third, a third, a third. That special needs child may need significant more, or it may need significantly less. So we actually have to do an analysis of where's the child going to live and what are those expenses are going to be coming up to. We take a look at, we run projections if the child would be living independently, let's say in a condo or an apartment, and services were able to come in and support that child. But maybe again, there's some medical issues that they would need more sophisticated care. Then we use other resources. National Care Advisors is a great firm to be able to go out and say, okay, this is what that medical care would actually cost. Then we actually have a firm number to be able to plan for. And at the end of the day, our philosophy is that the parents try and pay for those costs out of pocket. And really what we do is, once they're gone, the Special Needs Trust would then be funded with the appropriate amount of assets to last that child's lifetime.
So Ellen, one other thing that I'm going to put in there that Ken was touching on as well is, remember, oftentimes our loved one with special needs may already be receiving certain benefits, whether they are needs-based government benefits or perhaps entitlement benefits from their own work history, or in this particular case, like we're talking about, more likely from the parents' work history, right? And so one piece of the puzzle that we want to factor in is, what might those benefits look like? Because that helps to offset what could be additional costs that otherwise would need to go into that third-party special needs trust to help provide some of those quality of life extras, right? So it's a blending, not just of the resources oftentimes that the parents or perhaps extended family might already be wanting to set aside, but then it's, let's look at some of these other resources that our loved one may be eligible for off of their work history or other family members' work history too. So it's a combination of them.
Yes, yes. Because I know like some families, they say, hey, I'm going to put in $5 million into the special needs trust. My kid doesn't need public benefits. I don't want that stigma somehow of, having to rely on the government. And yet that helps the money in the special needs trust stretch so much farther if they are relying on the benefits that their kid is entitled to. It's not even, you have to jump through some hoops. Well, it could be jumping through hoops to qualify, but that's what they're there for, right?
Right. And sometimes, parents saying, okay, gee, I don't want my child to be on Medi-Cal or Medicare or whatever like that. There's some like housing programs that's a requirement to get the subsidized housing. So even if you feel, gee, I don't need it, some programs that you may want to have your child take advantage of require that Medi-Cal or Medicare support.
Mm-hmm.
What a great point.
Oh, sorry, just to touch on one more thing, and we can't emphasize this enough. Remember, there's not a specific dollar amount that associates with a family that has one child, two children, three children, right? The whole spirit behind it is it's very unique and it's custom. And a lot of the funding that could go into a special needs trust is not just about the dollar and cents, the resources and assets, but a big piece of that puzzle, as I'm sure you know in your practice as well, is the communication and understanding of values and wishes and aspirations that we have too.
Yes, definitely. I'll write that memo of intent, everybody. Make sure that your successor trustee knows where it's going.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
Now, when you guys are doing these types of calculations, how long does it usually take? Like from if you meet with a client and you're talking with them and you're crunching the numbers and you're pulling in national care advisors, perhaps, what does that process look like?
I'll start it off then. So we set the expectation with many families when we are bringing them on board to start this planning process. Our goal is to have everything completed within 60 to 90 days, right? Now, with that in mind, okay, this is going to be a series of consultations that we are going to be having, but a lot of it is really dependent upon how organized the families may be. Now, when they're coming prepped and ready to roll, oftentimes from an introduction from someone like yourself or another professional, they usually have the resources that are readily available. Sometimes that's not the case though, right? So we like to set the expectation 60 to 90 days if folks do have all their information available. Sometimes it could take a little bit longer, like perfect example right now around the holidays, right? We have to be flexible with folks depending upon scheduling, upon travel, sometimes just because of health-related issues that may come up. But we would like to believe that within a number of months, we can meet with clients to have consultations and come up with a deliverable as to what the next best steps would be for their plan.
Awesome. Now, there may be some people watching this who already have a financial advisor that they love. All right. It happens. In that case, and I'm going to talk to you directly. Please don't feel like I'm trying to snarf you away from your financial advisor. That's not what I'm trying to do. But do you guys work with people who already have their long established financial advisor? Are you able to still work with them and the financial advisor can still keep their assets under management? What would that look like?
Yeah, let me take that. So we actually get referred into families from other financial advisors where they say, look, we handle the investment side or whatever, but we really don't have the expertise of navigating the maze of special needs planning, of government benefits and taxation and things like that. So we work actually with other financial advisors to be able to do that. And remember, we're fee-based financial planners. So much like an attorney, we charge a fee to do the written financial plan. That's half of the equation. Then the next half of the equation is, okay, how do we implement that plan? I think it's the same thing as with an attorney. You draft legal documents, but sometimes with the attorney can help you add things to the trust and retitling things and stuff like that. But the main deliverable is actually the written plan. Now, most clients do decide that they want us to implement those different decisions along the way, but we certainly have clients that either they already have a financial advisor or they like managing their own accounts and things like that. So we work with everybody. Our job is to give you a plan, give you a roadmap for the family.
The one thing that I will include on something like that as well is, right, oftentimes it's not uncommon, as Ken was saying this, to have the financial professional already in place that's handling the portfolio. They may have an insurance person that's handling the risk management. They could have their tax professional in there too. Like, again, our job is to be agnostic, to look at all of the moving pieces of the puzzle and to identify how do these pieces of the puzzle fit in, not just as a family, but then under the context of having a special needs loved one, because the rules change. They're different, right? And so at that point in time, when we come up with a plan and a deliverable, what I think it does is it opens the eyes of many families as, oh my, like there is a specialty niche in terms of this type of advice. How do we keep this process moving going forward, right? And that's up to each and every individual to determine what type of path and experience they want to have from there. We're here to help.
That's great. So much of what we do, I feel like, as professionals, is we make sure that the right folks are on the bus in the right seats. And it sounds like you guys really have such an important role on that bus to figure out making sure that this child is protected for the rest of their lifetime. They're not out on the street. They're not subject to financial predators. Their public benefits aren't interfered with. And that's really what you do. And so I want to thank you for really focusing in on this work. And we're so glad we partner with you on a lot of matters, and it really is a pleasure. So any last thoughts you'd like to share?
I think, one of our big credos is we would be the family's financial advisor, but we're always going to be the child's financial advocate. So we always pencil things, what's in the best interest of the child? Maybe we want the parents to pay a little bit more taxes now so that there's a nice tax-free benefit that goes into the special needs trust and stuff. So we're always looking from the perspective of what's best for the family, but especially what's best for that special needs child.
Excellent. Well, thanks so much, you guys. It's been a pleasure talking with you, and I feel like this is bringing great value to our audience. So I'm really grateful. Thank you.
Thank you.
Thanks for sticking with us through this public benefits and special needs planning masterclass. I hope it gave you clarity, confidence, and next steps for supporting your loved one. But remember, every family situation is different, and these rules can get complicated fast. That's where we come in. If you're ready to take the next step in your planning, or you want to make sure you're on the right track, we'd love to help. Visit cookmanlaw.com to schedule a consultation. We also have a lot of helpful resources on the site, so please feel free to take a look around. You don't have to figure this out alone. We're here to help.
If this video is helpful for you, share it to someone else who might benefit from it.